Good afternoon, everyone. It's Pablo Zuanic, Cannabis Equity Analyst at Zuanic and Associates. Thank you for joining us. I have the pleasure of having here the presence of Shane Pennington, well-known partner at Blank Rome and an expert, of course, on all topics related to cannabis reform and the legalities around it. Shane, welcome.
Thank you, Pablo. Thanks for having me, and thanks to everybody who's tuning in.
Look,
Do
I
you want me
mean,
to give my background a little
yeah,
bit?
let's start with that. I know that 90% of the people on this call know very well who you are, but just, please, yeah, remind us of your top level credentials and on this matter of cannabis, please. Thank you.
Sure, sure. Yeah, so I'm Shane Pennington. I'm a partner at Blank Rome LLP. I started my career doing appellate law and Supreme Court practice at a big firm before I got into drug policy. And the way I got into it was by working with Dr. Sue Sisley, who's a researcher who was trying to study cannabis and couldn't get her application to grow cannabis through the DEA. And we helped her get that license and begin to study and grow cannabis. And in the process, ended a really bad policy that had been in place for about half a century called the NIDA monopoly, which I won't go into here, but many of you probably know what it is. And in the course of going through that case, I was like, wow, this is a really interesting and important area of law that not many people with my background have gotten into. And so I decided that I would jump in. And the reason that I thought I'd be a good fit for it is because I kind of specialize in the areas of law that deal with challenging federal agency action. So the Drug Enforcement Administration, Department of Health and Human Services, Department of Justice, all those agencies, the alphabet soup of the bureaucracy. I work with them to accomplish things for clients. And then when working cooperatively doesn't work, we sometimes have to go to court. And so, in the process of, I'd say, the last 5, 6 years, I've been involved in all manner of things dealing with cannabis. Most recently, and most importantly, I was the lead counsel for two parties in the administrative law judge hearing process on rescheduling Village Farms and Hemp for Victory. So, I was the only attorney or the only lead attorney representing the industry in that process, and I still am. And I'm sure we'll get into the details of what's going on there. But if there's anything having to do with federal cannabis or really federal controlled substances policy, I have a hand in it somewhere, some way, for better or worse.
Of course, of course. No, that's great. Thank you for that introduction. Look, before we have a lot to cover, but we're going to try to do two things first. One, go through some terms in terms of what they mean, and also two, key people involved in this whole process. So let's start with the people, right? Please indicate the government bodies potentially involved in this process and roles, and if any. And also, key individuals, right? And if they have any prohibitionist leanings that we should keep in mind, the AG Pam Bondi, DA Terry Cole, HHS Robert Kennedy, FDA Commissioner Marty Makary, and maybe I'm forgetting, I'm leaving some people out that I should include on this list, but let's start with that.
Sure. So we're pretty far along in the process with cannabis rescheduling right now. So a lot of these folks aren't going to be necessarily involved in getting this across the finish line or it fumbling at the finish line, whichever happens. But I will go over the people and the roles that they have in the process.
Mm.
So the first thing to understand is you have two big agencies, which we'll call parent agencies. And that's just a name that I use. I don't know if other people use it, but the idea is, just like you might have a large corporation that has subsidiaries or companies sort of under its umbrella, the same is true with federal agencies. You have the Department of Justice, which is a cabinet level agency headed by the Attorney General, which right now is Pam Bondi. What her views on cannabis are, I think, is something of a mystery. I know a little bit from some prior client engagements that I can't share, but I don't think I really have any better view into it than people who have studied that issue who only know public information. Suffice to say, it's anybody's guess exactly where she personally is on this issue. But then under the Department of Justice, you have many sub-agencies. One of them is the United States Drug Enforcement Administration, or the DEA. The DEA has delegated power from the Department of Justice, which itself has power delegated from Congress to oversee the enforcement an implementation of the Controlled Substances Act, the federal framework for drug control of these substances that are called substances of abuse, because people can and do tend to abuse them. And so those drugs get lumped into this statute, and then it's overseen by the Department of Justice, which has handed that role down to the Drug Enforcement Administration. But when Congress set the whole table for this, they didn't just want a law enforcement agency involved. In fact, it was a big debate back in the late 60s leading into the early 70s about, well, shouldn't we have the scientific and medical experts handling this more than we should have the law enforcement experts? It's a big debate. Long story short, they split the baby. They had a compromise where they said, we're going to have DEA be the point agency on it, but we're going to have the United States Department of Health and Human Services, HHS, handle the medical and scientific aspects of drug control. And under HHS, you have the Food and Drug Administration, FDA. And so the way the process works is Congress a long time ago put a bunch of drugs into five different categories if they were considered drugs of abuse. And those categories are one, two, three, four, five, and they're called schedules, which is a strange name for them, but in any event, that's what they called them. The schedules are strictest the lower the number. So Schedule 1 is the strictest classification. Schedule 2 is slightly less. 3, 4, 5 is the least restrictive. And so um, cannabis from the beginning, and it was actually not cannabis, it was marijuana with an H, which has a very technical definition under federal law, and a lot of people overlooked that. And because they overlooked it for so long, we ended up with a 2018 Farm Bill and hemp and the whole thing that we now have out there in the world. And so, leaving that aside, the way that it works is Congress placed a bunch of drugs into the different categories. Marijuana was placed in Schedule 1. There's a whole story about that that I won't get into, but suffice to say, it's an interesting one, and it was debated at the time. And in fact, the science pointed clearly, the president's own commission, it was Nixon at the time, said it actually shouldn't be in Schedule 1, but Nixon put it there anyway. And so there we were, and it's been there ever since because it's pretty difficult to get a drug out of Schedule 1. The reason for that is that um, you have to show that a drug has a currently accepted medical use and treatment in the United States or a currently accepted medical use with severe restrictions to get it out of Schedule 1. So Schedule 1 and 2 are essentially, well, they are the same with that one exception. The drugs in Schedule 1 are considered to have this currently accepted medical use. Those in Schedule 2 are not. So this is where HHS and FDA come in. When a drug goes through the FDA process and gets approved for interstate marketing as a drug, so you think about pharmaceutical drugs that we're all familiar with, a pharma company puts up $1 billion, discovers a new drug, it researches it, brings it to market through the clinical trial process. At that point, if they find out that if it was a Schedule 1 drug and it gets approved, then it is considered to have a currently accepted medical use and it moves out of Schedule 1. And there have always been other paths to move it to prove currently accepted medical use. But historically, the only one that really worked regularly or routinely was FDA approval. And so that's a big part of why it's been so hard to get cannabis out of Schedule 1 because getting a plant through the FDA approval process is difficult. And that's not to say that cannabis doesn't have medical use. That's the debate, right? But FDA oversees that drug approval process, okay? And it has a controlled substances staff that when a drug goes through that process, if it has an abuse potential, they will recommend that it be scheduled one way or the other. And so the CSA allows drugs to be placed on a schedule or moved from one to the other or moved off the schedules entirely on the motion of DEA, on a request from HHS, or on a petition from any interested person.
Right.
And so that's where it starts. That when that DEA will get that. They will then request HHS's evaluation and scheduling recommendation, which is a complex process that most of us have become familiar with over the past couple of years. And then with that recommendation, the DEA will decide whether they're going to start the formal rulemaking process. If they do, then historically, DEA would put a notice of proposed rulemaking in the Federal Register. There would be a notice and comment process, an opportunity for a hearing, and eventually a final rule. All of that done by DEA. So the role of HHS is really in this evaluation and recommendation stage at the beginning. DEA generally handles the rest. With cannabis, it's gone in a bit of a different direction because of all the drama that ensued. And, I'm sure we can get into that if we need to. But this time, DOJ took the reins because, again, if you remember at the beginning, I was talking about DOJ is above DEA. And so the authority that DEA has comes from Congress to DOJ to DEA. And so, DOJ giveth and DOJ taketh away, right? And so when DEA wasn't doing what DOJ wanted, DOJ took back over in this case.
We're going to go through it in detail there. And just one follow-up quickly. And
Sure.
we want to unpack a lot of what you said there. But can you give an example of a drug that was in Schedule 1 that was either descheduled or rescheduled that we can think of?
Sure. So Epidiolex is CBD. Epidiolex is I forget what they call it, the
Yeah,
market name, the product name
yeah,
of cannabidiols,
right. Yeah,
CBD.
right,
And
right,
it's derived from the marijuana plant.
right.
And at the time, back when it went through the FDA process, which it was going through the FDA process for years and years, but I think it was 2015 or so when it got through the FDA process finally.
Yeah,
And so FDA recommended that it be moved to Schedule 5. The
right,
issue was that at that time, the way the definition of marijuana was, this was before today it would be hemp because of the 2018 Farm Bill. But at that time, the 2018 Farm Bill had not defined hemp the way that it does today, so it counted as marijuana. And so DEA said, well, now that it has a currently accepted medical use, we agree it should be moved out of Schedule 1. But the issue was there's this treaty that the United States has signed, the Single Convention on Narcotic Drugs. And there were arguments at that time that there's no way to move a drug out of Schedule 1 or 2 to get it any less restricted than that and still enable the United States to comply with these treaty obligations. DEA considered that. It was heavily debated inside the government. And eventually they decided, no, what we can do is we can move it to 5. And then whatever else needs to be done for treaty compliance, we can make separate regulations for that. So that's what they did. They moved it to 5. And then they imposed some import-export requirements, record-keeping requirements that wouldn't ordinarily apply to Schedule 5 drugs, but they do to CBD or Epidiolex. And that's how they moved it to 5. Then, when the 2018 Farm Bill was passed, because CBD is hemp, it's now off the schedules. And so that shows you two ways that a drug can be moved from one to different schedules. One is through the administrative process, the other is through legislation.
right. Yeah. No, thank you for that. Look, and before we get into the meat of the discussion, of course, the president's plans to potentially reschedule. In social media, sometimes we hear, and even in the mainstream press, sometimes people talk about terms, or a lot of the influencers, they use these terms as if they were synonyms, right? Rescheduling, descheduling, decriminalization, federal legalization of medical cannabis, legalization, I guess, of rec, right? So people use those five terms as if they were the same. Maybe just, brief technical definitions and why they are all different.
Right. So let's start with rescheduling. Rescheduling is just moving a drug from one schedule to another. So from 1 to 3, say, with cannabis. And that is different than legalization because cannabis in Schedule 3 would remain completely federally illegal. All of the same restrictions that apply to cannabis in Schedule 1 would apply to it in Schedule 3. The one difference, I mean, there are certain regulatory differences that are out there, but in terms of your criminal legality or illegality, it's all exactly the same. The only difference is one criminal provision from a different statute, the U.S. tax code, would no longer apply to cannabis, and that's Section 280E of the Internal Revenue Code, which I think we're all familiar with. That would no longer apply to it because that provision applies to trafficking in Schedule 1 or 2 drugs. So rescheduling would not be legalization. Legalization is actually a nebulous term that I don't even know if anyone has a precise definition of,
Mm,
because I think when you tell a layperson, well, we're going to legalize something, it has this they have this image in their mind of it being just this free for all, when in fact with drugs and things that people are consuming, they're heavily regulated even when they're the most free of government interference that they can be.
right.
So for example, even if cannabis weren't on the schedules at all, the Food, Drug, and Cosmetic Act would still apply to it. And so you couldn't market it in interstate commerce as a drug without FDA approval, even if it were descheduled. And so now let me give the technical definition of descheduling.
Right.
Descheduling is when you have a drug that's in Schedule 1, 2, 3, 4, 5, and you move it completely off the schedules entirely, so it's no longer a controlled substance, the Controlled Substances Act no longer applies to it. And again, when you talk about descheduling, I think a lot of people think that that means that the federal government just isn't involved anymore, which isn't true. The Food, Drug, and Cosmetic Act still applies 100% to, I mean, aspirin isn't a controlled substance, but it, you better believe that the FDA regulates it, right? And so the reason that we don't see FDA interference with cannabis or DEA interference that much with it these days is because of enforcement discretion. And the federal government, just because a law's on the books doesn't mean that the federal government always enforces it to the hilt. Sometimes it enforces it 80%, sometimes 100%, sometimes in the case of cannabis, very little, and with FDA, very little. And there are reasons for that that we could get into that are actually pretty important. But for purposes of answering your question, rescheduling, moving from one to the other, descheduling, moving off the schedules entirely, legalization, I don't know what that means, but I think people think it means some descheduling plus or something. But I don't, you will never hear me use that term because I don't know what the substantive content of it is.
Right. And decriminalization?
Decriminalization would be removing a drug from the criminal code implications. And even there, I think if you moved it off the CSA, the vast majority of the federal criminal prohibitions related to cannabis would disappear. But that doesn't count state law, right? And so states could still make something criminally prohibited, even if the federal government doesn't, as long as there's not express, preemption applicable to it, which is a whole other can of worms. The point being, criminalization has to do with the things that you could go to prison over, right? It's a crime, as opposed to maybe a regulatory fine or losing a license over it or something like that, which is considered more regulatory or civil in nature.
Yeah, no, thank you. That's great color there. I appreciate all those answers. So look, I mean, moving on to the meat of the discussion, right? So assuming the president decides he wants to move ahead with rescheduling, and here I'm just focusing on rescheduling, is there only one path for him to do this? Formal regulatory administrative process or more than one path? And again, I'm talking here again at the executive branch level, right? Not anything through Congress. So,
Sure.
I want to pack this a little bit in terms of the question, but please discuss the various paths, options for him and the steps involved, timeline. For example, does he resume the Biden administrative process? Is this a choice or must he stick with that process if he wants to reschedule? Or does President Trump start a whole new process? Or can he just reschedule with a stroke of a pen via executive order? Or are there other alternatives? Let's go through that.
Sure. So the answers here are going to be a little bit technical, but it matters because people debate these things constantly in a very confused way all the time in public. And so pardon me that they are a little bit technical, but this is administrative law. It's boring. So, buckle your seatbelts, get comfortable here. So, um, the president, there's not a whole, there, the president is both extremely powerful and then yet technically he can't just do this, right? So there's a lot of people who say, well, he could just issue an executive order and cannabis would do whatever he said, in that executive order. I think what they mean is he could direct the agencies to do something in an executive order. That is to a large extent true. He is the commander in chief of the executive branch. All these people work at his pleasure. He can do a lot in terms of leaning on them and imposing his will on them. That said, he cannot, by the stroke of a pen, reschedule, deschedule cannabis. Because the reason is we have separation of powers, and there's a statute called the Controlled Substances Act that sets a process by way of which
Right.
cannabis moves from one schedule to the other. And because that was passed by Congress, which is the legislative branch, the executive branch can't just be like, well, I'd rather not do what Congress said, and I'd rather do it a different way. That's not possible, at least not legally. And so you have to go through the statutory process. That said, the president has a great deal of control over federal agencies that work under the executive branch, so he could direct the agencies to do something or not do something, do it one way or do it another way. And within that administrative process, there's a good deal of flexibility. So, for example, they could just they wouldn't really have to resume the process. The process is ongoing, it's pending.
Right.
So he could just say, you know, we're going to go forward with this and we're going to get it done quickly. He could command the agencies, or they could decide on their own, however that wants to happen internally, that we're going to continue with the ALJ hearing and have a big full-blown trial over it. Like we had a 3-month trial scheduled, as many will recall. They could do that. They could say, no, we're going to cancel the hearing. And there are standards that they would have to adhere to if they were to do that. He could say, well, I want to know the end point of this interlocutory appeal that's pending or not. Um, he could also just say, I've seen enough of this, cancel the hearing, enough with the interlocutory appeal. I'm going to go straight to final rule. In this context, DOJ in the notice of proposed rulemaking said DOJ is going to issue the final rule. So DOJ could issue the final rule. It has the authority to do that. It assumed that authority in the proposed rule. That could happen. I presume also that they could say, well, that was the old DEA that they took that power from, and the old DOJ did that. We want DEA to do it because that's the way it's been done, and we think DEA is fine to do it. And so we're going to delegate that power back to DEA. DEA will issue the final rule. Each of these paths would require different levels of explanation and engagement. They could also say, what a mess. Let's start over, right? Now, I don't want that to happen. And I want to be clear about something. When people ask me what could happen, it's like asking what sort of weather events could happen on
Right.
any given day. A
Yeah.
lot of things can happen. Are they likely to? That's a different question. But if you're asking the scope of what's possible, he could cancel the entire process that's pending, start a completely new one. He could go straight to final rule. He could see this process through to the end, through the hearing process, the interlocutory appeal, the full bells and whistles, and get there that way. He has
Right.
all those options.
So
Finally, just for completeness, he could just cancel the process and say nothing,
nothing.
just
Right.
cancel it and
Right.
do nothing. In which case, somebody could petition again, or Congress could take it up, or
Just
whatever.
just staying there. Okay. So in terms of, let's say he wants to go on with the process, I hear you say that he has two options in that case. One goes straight to final rule, which I guess means the DOJ, the AG writing the final rule. Or the other option was not go straight to final rule, but restart the process that's ongoing, right? I guess, go back to the interlocutory appeal that we were talking about. I mean, just touch on those 2 points. And in this whole discussion, also, is there a path that you prefer, or that you believe it's more airtight from a legal challenges down the road point of view?
Sure. So the thing to understand about the ideas of resuming an interlocutory appeal or resuming anything involving the ALJ, that gets complicated right now because Judge Mulrooney, Chief Judge Mulrooney, has retired,
Right.
and there are no more DEA ALJs. They don't have any ALJs. So who would be the adjudicator if the hearing continued? They'd have to find one to adjudicate. Could they do that? I'm sure they could. They could appoint a new ALJ, or
Right.
they could say we're going to have the Attorney General oversee the process, or something like that if they wanted to.
Right.
But here's the thing. There's good reason to question whether they want to do that, and that is that the Department of Justice under the Trump administration has said that we think that ALJs, at least DOJ ALJs, which that's the ones we're talking about here,
Yeah.
um, are unconstitutional. I won't go into the full constitutional law lecture of why. It has to do with their tenure and how beholden they are to the president. But the point is that without an ALJ and without an adjudicator, it becomes a bit more complicated to see it through. And there's good reason to suspect that this administration might not want to do that since they've said that they won't defend the constitutionality of ALJs in federal court. It would be surprising to me. The second part of your question about, do I have a preference? And do these different mechanisms have different vulnerabilities on judicial review later? The answer is my preference is that they go directly to a final rule. I'm happy to see the hearing through. I don't know how that would look. I mean, I would like to have, I was geared up for a 3-month trial and ready to, have a big fight with Bill Barr and Kevin Sabet. And that's something, from my personal perspective, would have been a lot of fun. But from my client's perspective, we have a great record, right? And we have all the science and evidence behind us. At this stage, the opposition, I think, has shown themselves to be corrupt and colluding with DEA throughout the entire process. And we've built a big record that proves that kind of without question at this point. And so I'm very happy going to court on the record that we have. And it's important to also understand hearings in this context are very rare. So they do happen, but they are the exception, not the rule. And so it wouldn't be unusual at all to have this process end with a final rule without seeing the hearing through, especially under these circumstances. And I'm very comfortable going to court with this record. So if I had my way, we would get a final rule out as soon as possible. Now, last thing I'll say about this is it's important for people to understand because a lot of people are like, why do we need 2 weeks to get a final rule? This has been going on. I mean, this should have been done 50 years ago. Fair enough, but remember, this is going to be in court, okay? And
Right.
when it goes to court, they're going to look at the record. They're not going to look at anything outside of the record. And that final rule is what will be the target of the judge's greatest scrutiny. They're going to read what that final rule says. And under the Administrative Procedure Act that governs everything that agencies do, they have to give a reasoned explanation for that final rule, which means they have to address all significant comments that they received. And if you recall, there were 43,000 plus public comments. Most of them were very positive for the rule, but not all. And it's important that they address significant concerns that were raised in the public comment period. And that takes time. It also takes time to actually draft a final rule. If you recall, the proposed rule was, many, many pages long. It was detailed. The final rule has to be at least that robust, and they need to abide by all of the little rules that apply to agencies and how they do things like this. And so that takes time. Does it take years? It shouldn't. I could do it. I could knock it out quickly. And I'm sure that the DOJ can as well. But I just want people to understand it's not like they just write, done and it's done. They could, but if they did, that would not survive judicial review. And that's not what you want. So we need them to do it right, quickly and correctly.
Right. But just on that point, and I know we're getting here very wonky, but that's what we want. So I'm probably oversimplifying here what you've said, but so they probably don't want to restart the hearings, and they would prefer to go straight to final rule, and of course write a very robust final rule to make it legally airtight, right?
Yeah.
But someone could
Well, I don't know
say,
what they want, but that's what I want.
right, that's what I hear you, yes.
Yeah.
But I mean, but assuming that they want to reschedule, that would be
Yes.
the optional, the best path forward, right? It would seem.
In my opinion, that would be
Yeah,
the best path.
right.
Yeah.
However, what if someone said to you, even though you government don't want to do the hearings again, the DEA never ruled on the appeal in the existing process. So you cannot kill the process because in a way it's pending, right? And again, I'm going to read here the technical term. The ALJ denied a motion to disqualify the DEA from defending the proposed rule and granted an interlocutory appeal, canceling the main hearing scheduled for January 21st and pausing the proceedings pending the appeals resolution. So somebody
Yep.
can say to you, you know what, you can't cancel the process because it's under appeal. What would you say to that?
I mean, they're incorrect. You absolutely can. It happens, it's not the most common thing in the world, but there's definitely precedent out there where there
Right.
are many reasons you can cancel a hearing. You can cancel it because it was improvidently granted, which, in this case where you see that when the process did start, it was nothing but collusion between one side and a bunch of insiders in the agency that the ALJ himself said was, astonishing,
Right.
astonishing behavior from the federal agency. I think you could say that they weren't really after the science and evidence as much as they were holding this entire process hostage, which is what they've done and tried to do. It undermined the, public faith and the legitimacy of the process to watch that drama unfold. And there's no reason to let that go forward. That's one basis. Another basis is you can just look at the record and see that there aren't any questions remaining with respect to factual issues that an ALJ would be competent to oversee at this point. We
Mhm.
have a robust enough record. It's sort of like in other legal contexts, you may have heard of summary judgment. We have enough evidence that there's no longer a material fact there for us to adjudicate. And where that happens in court and in ALJ processes, the adjudicator will say, well, there's nothing more for me to do here. It would be a waste of public resources. I'm not going to continue when the record is this clear. That would be another basis. Yet another basis would be, even if we wanted to proceed, we don't have an ALJ anymore. So what exactly are we supposed to do? And when you put those three things together, I think there's plenty of basis for them to cancel the hearing. If they want to go forward with the hearing, of course, again, as personally and as a lawyer, I
That's
mean,
business.
that's something people need to understand. Like, I live for this, right? This is what I want to do
Yeah.
in my personal capacity. But what I'm saying is what the law allows is much broader, and they can certainly cancel that hearing. Here's the last thing I want to say about this is a lot of people are concerned, well, what about the parties in the hearing, and aren't they going to be squawking about, well, I had a right to a hearing? There's a due process right to a hearing in an adjudication. So say that you have land that has some kind of, bird on it that the government wants to protect and they come and want to take your house. You have a right to a hearing before they take your house. You have a right to that opportunity for a hearing in that case because they're going to go take your property from you. This is not an adjudication. This is a rulemaking process. The statute says that they have to provide an opportunity for a hearing. And it's important for people to understand that historically there have been hundreds and hundreds and hundreds of rescheduling processes, and only a handful have ever involved a hearing. Okay? So this idea that there's this vested right to for this hearing to take place is just wrong. It's not true. And even in the adjudication context, hearings are canceled where the record is so clear. So for those reasons, I would be perfectly comfortable as long as it was, explained in the ways that I've described with them canceling the hearing. Certainly, people would still complain about it, but that's going to be the case no matter what we do. I can assure you of that. There's no way the opponents of rescheduling are just going to lay down no matter what how this goes. And on the flip side, if they were to stop this or do it the wrong way to keep cannabis in Schedule 1, everybody knows that I'm going to be on the other side complaining about that, right? So this is going to be debated. The
Right.
key thing is for it to be done in accordance with law and explained in a thorough and clear way.
Right. So look, I mean, I want to unpack some of those comments there, and I know that the president right now has said that they are looking at it, right? And that's not a formal administrative process, right? That's he's looking at it with his teams, and they'll make a decision. We don't know what that process looks like, but let's say that they go through that process. I'm just trying to understand in terms of what they announce, right? So they would announce, look, we have decided we're going to reschedule. The AG has decided that she's going to stop the hearing and she's going to start drafting the final rule, which will be out in a month's time. I'm just trying to understand how much color are we going to get from them, and are they going to give us all those pieces? Or he may just say, you know what, we decided we're going to reschedule. We'll let you know the details later. Just wait and see.
They may not say it would be unusual for them to say in advance what their decision was. Like
Before the rulemaking, or really before the formal.
that would be unusual.
Okay,
That doesn't mean somebody might not leak it or the president, this particular
right,
president might not say it publicly. I'm just saying it would be very unusual. The way it normally works is what would happen first is they would cancel or withdraw the hearing, which, declare the interlocutory appeal moot.
right. And
And by
they have
they,
to
I
announce
mean,
that publicly, right? There would to be a formal announcement of that, a public formal announcement that we would know about.
you would know about it. I'm not sure if they would come out with a press conference. I mean, that's up to them with how
Right,
they want to roll that out. But you would almost certainly know about it because I would get a notice of it and all the parties to the hearing, and surely somebody would tell the world that this has happened,
right,
right? The press would know about it the same way that they've known about other things that have happened in the hearing. In other words, those things weren't announced publicly, but they became public once they happened. And so now, whether DEA would do that or whether DOJ would actually take that formal step is a good question. I mean, I think it could go either way. Um, but in any event, they would have to, withdraw or cancel the hearing. Um, the interlocutory appeal at that point would be moot.
Right.
They could cancel it anyway. They could say it's moot, but we're canceling it for these reasons and say whatever they wanted to say there. Then presumably a final rule would come out.
But hold on
And
one second, hold on. And remember here, it's because we're thinking in terms of stocks, right? And people are looking at this like on a second to second basis.
well,
So
y'all
just
are thinking about
right,
stocks.
right, right.
I'm not,
So
but y'all are.
I know, of course. So what I'm saying is that, okay, so we hear from lawyers like yourself, hey, they canceled the hearing. They could have canceled the hearing because they decided they're not going to reschedule, or they could cancel the hearing because they just want to move in a speedy way to final rule. What I'm trying to think is that when we hear that they canceled the hearing, do we know what they are up to? Or not
Well,
necessarily?
not necessarily.
Right.
And here's something about this that everybody doesn't like, but you should understand. Things can change. They can change their mind. Like they could cancel a hearing, be on a path to, first of all, canceling the hearing could be a preparatory step for a final rule that says we're keeping it in Schedule 1, or we're moving it to Schedule 2, or we're moving it to 3, 4, 5, right? Like there are lots of things that can happen from that point,
Right.
and you don't know which one it is. What I would say is, I mean, I will be online telling people to slow down with their proclamations of victory if the hearing is canceled and everybody's saying Schedule 3 is happening, it's done deal, da 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 da. I've been saying this for years. I've been online telling people this. But it is true that it would be consistent with the path that I came on your podcast and have written about before and have said for a long time that I think would be the best path to move to Schedule 3 in the best way. And so I wouldn't take it as a bad sign if that happened. I just also wouldn't think it meant that the cake was baked and we're ready to put the candles in and have a party. Does that
Right.
make sense?
Yes. And so even if they decide to keep it in Schedule 1, there has to be a final rule. I thought the final rule is only if they decide to reschedule.
There doesn't have to be a final rule. They could with just cancel the whole process or just stop it and never start it again. And cannabis would just remain in Schedule 1 and there would be no formal
Right.
announcement. This is important because if I were the president, and I'm not the president and I don't know the president, but if I were president and I wanted to keep it in Schedule 1, I just wouldn't do anything.
Right.
I
Sure.
just wouldn't do anything. Now, eventually you would probably want to do something because the same statute, the Administrative Procedure Act, says that you can sue to compel agency action unlawfully withheld or unreasonably delayed. So after a certain amount of time, somebody could sue to force them to make a decision on it
Right.
formally. But politically, if it were me and I had a decision like this and I wanted to do it the best way I could, if I were trying to keep it in Schedule 1, I wouldn't do much of anything for quite a while. Nothing, because it's still in Schedule 1 and I don't need to do anything yet. So that's what I would do. So if you see steps taken, to me, from my perspective, that's better than nothing. And it is consistent with where we want to go, especially if it's going down the path that I've just charted for you that I think is the best path forward. But until we actually get that final rule, moving cannabis to Schedule 3, we don't have it. And even once we have it, there will be litigation. So people need to understand that, it ain't over till it's over.
Right.
I
Right.
hate to say that. I know people don't like that, but that is the truth.
Okay. So let's stay there for one second in terms of that litigation. So first of all, how can I ask this? I guess, and these are, call them devil's advocate questions, but
Sure.
did the 252-page HHS document cut corners, right? I mean, it's a two-part test, airtight administratively and legally, right? Camo and potential for abuse. And related to that, seems that the DEA wanted a longer test, right? The 5 points as opposed to the two-part test. So just on that point.
Sure. So the 252-page analysis is the most robust and thorough
Right.
document of its kind in the history of the Controlled Substances Act by a strong margin. It is plenty thorough, plenty robust. That doesn't mean that they don't have to respond to significant public comments. That doesn't mean the final rule should just point at it and be like, whatever, right? We should still have dot our I's and cross our T's in that final rule. But that is a very solid. basis. Now, you brought up the particular problem of the five-part standard versus the two-part HHS standard. I think that the two-part standard is eminently sensible. And in fact, in the marijuana context in particular, I think the five-part test is illegal. And I'm not alone in that. I mean, I've litigated that point. We never got a court to reach the merits of it, but we did get one judge concurring in an opinion, a respected judge on the Ninth Circuit, Judge Watford, to say, look, we're not going to reach the merits of it, but that five-part test does look pretty bad, which, you know, it's not that it's bad for everything. The way I look at it is there's more than one way to show currently accepted medical use, and everybody agrees about that. FDA approval is enough for sure. The five-part test, meeting that standard, which is very similar to FDA approval, is also enough. But the fact that a drug isn't FDA approved doesn't necessarily mean it doesn't have currently accepted medical use. The easiest way to understand that is for FDA approval, you have to have a drug sponsor willing to pay $1 billion to get a drug through the process, right? And when you have a drug, the reason that pharma companies are willing to pay that money is because they know that they'll get a monopoly on the drug when it comes to market after FDA approval. But guess what? There's already tens of billions of dollars of market out there for cannabis, and so nobody's willing to front that cost for cannabis. That doesn't mean that it wouldn't prove safe and effective if somebody did. The other thing is, even if something is safe and effective in the clinical trials, there are patent requirements and all sorts of details for FDA approval that have nothing to do with whether the drug has currently accepted medical use. So FDA approval alone obviously isn't the only path. Even DEA agrees about that. The five-part test is certainly enough to show currently accepted medical use, but it's not the only way, right? There are other ways. And in 1982, HHS in fact said that it's possible that intrastate production and use of a drug could be enough to show currently accepted medical use. And that's exactly the test that they fleshed out here. Because at the time in 1982, there was no such drug that had, through intrastate production and use, shown currently accepted medical use. But now, with 40 states and however many territories, doctors using it in treatment with patients across the country, and these are state licensed healthcare providers. And in our system, the states have authority over the practice of medicine. So, where that's the case, it's very difficult for the federal government with a straight face to be like, well, it's true, it's currently being used in treatment and accepted by thousands of doctors and millions of patients and so forth, and yet it doesn't have a currently accepted medical use. The HHS two-part test reflects that obvious reality, and I think it's a very good one. Beyond that, it's backed by the Department of Justice's Office of Legal Counsel, which is the highest
Right.
level statement of law you can get in the executive branch, short of the president or the attorney general. And on that point, the attorney general is the one that put out the notice of proposed rulemaking, accepting OLC's conclusions. So at this stage of the game, we have the best, most robust authority supporting every little step of that process, which is why Sam and Kevin Sabet are freaking out about it, right? That's
Yeah.
why
Yeah.
they're up in arms. It's pretty good. Does that mean that it's a lock? There's no way that something else that it couldn't go wrong from here? No, things could go wrong, right? I mean, this is cannabis, people. This
Right.
is the
No, sure.
federal government and cannabis. You don't count chickens when you got eggs. But
And
we're in a very good place.
right, but just on that point, in terms of the legal challenges, right? So the legal challenges, if there's going to be any, and like you said, you expect there will be, they will have to come after the final rule has been filed and published, right? Not before. I guess the only angle or window I see before that is that they could complain that the hearing shouldn't have been canceled, but maybe there are other paths. And I'm not trying to tell you here to give advice to the people that want to stop this process, but yeah,
No, no, I understand. I mean, the fact is, I often get calls from potential clients saying, "Can I sue?" Well, yeah, you can. I mean,
correct.
people can go to court whenever they want.
Right.
The
Yeah.
way that the APA and judicial review of agency action works, though, is suing before you have final agency action is very rarely countenanced by a court. They very rarely will intervene in an ongoing agency process until the cake is fully baked and you have a final rule. So somebody could sue, they could try anytime they want. In fact, many of you know that my good friend and now Deputy General Counsel at HHS, Matt Zorn, actually sued very early in the process because he didn't think the way that the 25 parties were assigned in the hearing was kosher. And I mean, it wasn't Matt himself, but it was his law firm who did that. And so that case ended up being withdrawn eventually.
Right.
Point is, people can sue if they want, but that is very rarely does that go the distance.
Yeah.
Ordinarily, 99% of the time, you have to wait till the final rule. And that's when I would expect it to happen. And to be clear, I think you have 60 days under 21 USC 877 to bring a petition once the final rule is published.
Right. Got it. Look, we're going to move on the discussion. I know we've taken a lot of time here already. For those of you who have questions, please email them to me or put them on the chat room here. I'll read them out. We don't take live questions, but I will read them out. Look here, Shane, I want to ask you to like try to get inside the president's head, right? And of course, so it's a very tricky question, right? But and I realize we may be guessing here, but with the president right now looking at it, right? Rescheduling, I mean, and him having said various things, including some people hate it. It's a complicated process. He's talked about medical value. In terms of what he's doing right now, there is no formal administrative process for this, right? In terms of looking at it. But what do you think his looking at it process actually really means right now? And I know that we're not talking about something that's formal, right? Is he calling Pam Bondi and saying, hey, I want to get this done? Or Pam, what do you think? Or is he calling Robert Kennedy? And I know we're guessing here, but what would be your feel of how this is playing out right now? Because he's supposedly looking at it, right?
Sure. So as you said, like I don't know. I don't know what looking at it means, but what I do know is what I said earlier. If I were the president and I didn't want to reschedule, I wouldn't have said anything publicly about it. That doesn't mean because
Right.
I'm not the president. But if it were me and I were and I said something, that would be because I was seriously considering rescheduling or I thought that was the path I was probably going to go. That's just me. And I think that makes sense, but I don't know President Trump. Now, what could looking at it mean? It probably means what do we do with this hearing? What do we do with this interlocutory appeal? What does that final rule need to look like? What do those public comments say? Which ones do we need to respond to? Who should write this thing? Should it be DEA? Should it be DOJ? Those are the kinds of things that I would assume. They might also be looking at, I know in the proposed rule, there were some questions about the OMB process and looking at the economics of the issue. Well, they have new economists in the White House now, right? OMB is run by different people now. They might want to dig into that. And I want to be clear, just because he said this on this day doesn't mean they weren't already looking at it,
Right.
right?
Yeah. Yeah.
They could very well have been looking at it. They could be on their fifth draft of a final rule. We don't know. Or not. They may have just picked it up. We don't know. There's no one. If somebody has those answers, it's because they know them from the inside, and I don't have that information, unfortunately.
Thank you. Look, just moving on here. And obviously I hear everything you're saying. So let's say in the event he decides rescheduling cannot be done for whatever reason,
Uh-huh.
but he still wanted to do something for cannabis. What could be other potential wins options for him, realistically speaking? And what would be the process and how could he get them done at the executive branch level? I'm talking, let's say he decides more research is required. How would this be done? Or he decides, you know what, I'm not going to reschedule, it's too complicated, I'm going to deschedule. Does he have to defer to Congress? Or does he like try to get federally legalized medical cannabis? Again, maybe he has to defer to Congress. Or maybe he just says, you know what, I'm just gonna do something for veterans here, and I'm gonna get the VA to start doctors to start prescribing cannabis. I know there's a lot there, but I'm just trying. Let's say, obviously, I'm not speaking for the president, but let's say I decided, well, rescheduling is just too complicated, but I want to do
Mhm.
something for the cannabis community. What are my options?
There are many,
Sure. Yeah.
but none of them are going to do what rescheduling would do. I mean, the main thing that he could do is lean on Congress to fix the issue would be one thing.
Mm.
Another thing could be, I mean, if I were him, I'd look at this treaty that seems to be a block to descheduling, which it is a big obstacle.
Yeah.
And I would say, why is the UN telling us how to handle drugs in this country? Who gave the UN the right to tell American doctors what drugs they can give to veterans, you know? And if I were President Trump, believing in federalism and not really believing in, uh, you know, foreign organizations being able to impose their will on the democratic process of the United States, I would certainly want to get to the bottom of that and address that. So that would be a big one, getting to work on that treaty barrier and trying to figure out a treaty arrangement that makes sense for America and keeping Americans healthy. That would be one thing. Another thing is he could look at the criminal sentencing, and he could say these sentencing tables don't make any sense. I realize that the criminal penalties for cannabis at the federal level are going to be the same, whatever schedule it's on. That's crazy to me. These sentences shouldn't be what they are, and that's because there are things I could do right through the agencies to address that to some extent. In terms of research, yes. I mean, the president could say, I'm tired of not having this research. I want to have the biggest NIH study ever done, right? I want to have, instead of the Schaefer Commission, the Trump Commission that's going to redo that science. And if I get a commission that tells me to move cannabis out of Schedule 1, then I'm going to do it. He could do that as well and actually get the data and so forth. I mean, I could go on and on and on and
Yeah,
on and
yeah,
on. There are many things, but all of these are like, you know,
right,
trying to bail the Titanic
yeah,
out with
right.
a cup
It's just
compared to
politically
rescheduling.
what I worry about is that we all, of course, in the industry side, in terms of stocks, we want rescheduling to happen. But maybe a way of bailing out would be to say, okay, I can't get rescheduling done, but I'm going to do something for veterans. I'm going to do something for research. I mean, that would give him political cover. I mean, but it's just my opinion. But do you agree
No,
with
yeah,
that?
I mean, and since you asked the question, I answered it. I mean, the thing is, I
Yeah,
could
yeah,
keep
yeah,
going and going and
yeah,
going forever. He has a lot of tools
yeah.
on those
Last
points.
question before I understood. Last question, but before we move to Q&A. We've discussed the topic of bifurcation before, right? So I'm going to ask it in a very simple way. Given the CSA is supposedly a federal construct, does rescheduling, as proposed, de facto federally legalize medical cannabis by putting it in Schedule 3 and result in increased FDA oversight and the need for formal doctor RS prescriptions? And if not, why not?
So the answer is no, it does not. And the reason is because the Controlled Substances Act is a separate statute from the Food, Drug, and Cosmetic Act. The Food, Drug, and Cosmetic Act brings the full heft of the federal government's oversight over cannabis, regardless of if it's on the schedules or not. So even if it were descheduled, interstate marketing of cannabis as a drug would remain completely federally illegal, even if it were descheduled, because cannabis is not FDA approved for interstate marketing as a drug by the FDA. So there's nothing about this that stops that or impacts that in any way. It the reason that nobody's enforcing those laws is there are many reasons, but the main one I think is because think about the cost of trying to enforce the federal prohibitions on cannabis under the Food, Drug, and Cosmetic Act or the CSA, when you have tens of billions of dollars growing strong nationwide economy. I mean, it would take such an outlay of resources from an administration, by the way, that's trying to cut spending and from agencies that are having a hard time. If they want to do something, they have to cut 10 things before they can do one. And so the idea that an agency like DEA is going to muster the resources to be able to go do raids nationwide to shut down cannabis is it's ludicrous. And same the FDA. They would have to have so much money that where are they going to get it? I mean, normally the way they get money, they have two lanes where FDA gets money. Appropriations from Congress, which requires a law. I don't see that being passed by any Congress. Like go shut down the marijuana industry in the States. I mean, it'd be crazy. And it would cost so much, but there's that lane. Then they have the pharma process. They have user fees from pharma companies from FDA approved drugs. But again, because cannabis isn't FDA approved, they're not getting any money from that. So they just don't have, it's just practically impossible. And that's before you even get to the political side of it, which it would be wildly politically unpopular across the aisle, across nationwide, for them to go trying to enforce the cannabis laws. And if you want to see this in action, look at hemp. Hemp went
Yeah.
from Schedule 1 to off the schedules. And it's not like you see FDA and DEA raiding hemp places everywhere, that didn't happen. It won't happen. Like, is it possible that they could? It's possible, but it's just as like if I were an law enforcement person and I wanted to shut down cannabis completely, I mean, I think that's crazy. But if they wanted to, it would be easier to do it with cannabis in Schedule 1. Like you don't loosen the restrictions on something to suddenly clamp down on enforcement. And if FDA wanted to crack down, they could crack down on it in Schedule 1 right now because it's not FDA approved. So, and last point, again, if they descheduled completely, FDA could still clamp down if it wanted to. So it makes no sense to me to be like, well, if we move it to 3, suddenly everything's going to change in terms of enforcement because the reasons they aren't enforcing have nothing to do with the scheduling classification.
Right.
I hope that makes
No,
sense.
no, that's good. That's good. Thank you. Look, so I appreciate very much your time here. I know we're going to go over the hour maybe, but I'm going to read some questions here. So one question, the person says, if the final rule is filed in Federal Register as Schedule 3, and if there is litigation that follows, does Schedule 3 go into effect while it's being litigated, saving to ADE tax monies in the meantime, or does the court stay the ruling while the case goes on?
Ordinarily, just well, pretty much all the time, unless there's a specific, there are a few exceptions, but none of them would likely apply here. Once a final rule is published in the Federal Register, there's a 30-day delay before the effective date. And the agency can set that effective date to be, longer. They can sometimes say that it goes into effect immediately, but there are specific reasons that they have to have that I don't think would apply here. So it's going to be a 30-day delay. During that 30 days, people can petition for review of the final rule, and a court has the power to issue a stay of the final rule's effective date under certain circumstances. It's hard to get that. It's unlikely, but I would imagine that the opponents of rescheduling will, right off the bat, file a petition for review and move to stay the effective date of the final rule, which is why we have to be absolutely geared up and ready to fight once we get an announcement.
Right. Okay, here I'm going to read the name of the person asking the question because he's been involved in some of these things. Dwayne Boise, which I'm sure you know, he says, please address the administrative law system and why it's unconstitutional and why Pam Bondi said she wouldn't defend MMJ's challenge. Why not file a writ of mandamus? And again, if you don't want to get into the details here, I know it's complicated, but Dwayne has his own suit going on there, right? Or you can skip that if you want.
Sure. So, there's precedent out there for people to read about why some courts have said that ALJs, the way that their tenure works and their appointment works, is unconstitutional. I hesitate to give uh, like a law school level lecture about why that is. You can read those cases. For our purposes, the point is that it appears that the Solicitor General of the United States and the Department of Justice agree with those arguments. And so because DEA ALJs are appointed and tenured and hired and fired the way that they are, um, they fall into that bucket of uh, public servants who DOJ apparently believes are unconstitutional. And when I say apparently, I don't want everybody to think that I agree or disagree. That's really neither here nor there. I mean, for what it's worth, I do think the constitutional argument is sound. I tend to think that there is a problem with the way that the way that that system works. But I think it would take too long given the time we have for me to go through it. But people are, those cases are out there. You can read them if somebody's really interested, or give me a call and I'll happily bore you to tears
Yeah.
with the 2L lecture.
Gold Blank Rome LLC. Yes.
Yeah.
Look, I'm going to paraphrase a couple of questions here that I may have asked before, but maybe it's more for you to unpack them a bit more. Um, and remember, we're looking at it from a stock perspective, right? In terms of what headlines do we get. So again, we may hear that they cancel the hearing, and we will know about that. If they decide they're going straight to final rulemaking, do we know that that's what they are doing, or we don't know until that's filed? I mean, could we be guessing that are they writing the final rule or not? I mean, how do we
You
know
could
that?
be. It depends on what they tell you.
Right.
It
But
depends on what they
they could
decide to
actually,
tell you. Ordinarily, they wouldn't tell you.
right.
Ordinarily, you know there's a final rule when it's published in the Federal Register.
Right. But in this case, you could make the assumption that given that it's so political and the president has talked about it, he says, look, I told Pam to get it done and she's writing the final rule. That's my assumption, I guess.
You could assume that. He also said that he was upset that someone had leaked the news that did leak that prompted him to say that they would be getting it done in 2 weeks. And so maybe he doesn't want that news leaked and maybe people will not leak it. I don't know. I don't know. What I do know is ordinarily you know that a final rule is real when you see it in the Federal Register.
Right. And like we said, once it's in the Federal Register, there's a 30-day for judicial challenges, which, let's see what happens. They may or may not be stayed. But if during those 30 days there are judicial challenges and they are not stayed by the judge, then it becomes effective, right?
Yes,
And we have
that's right.
Schedule 3.
And
Right.
a stay is I'm not saying it's impossible, but it is a very high standard, and the Supreme Court has made recently that standard significantly higher, not easier. So I think that's unlikely, but it is a risk.
Right. And on this point, on the litigation, because of Chevron, I guess the chances that those challenges succeed are less, right? In the sense that the judicial branch doesn't set the rules, they give precedence to the agencies, right? You want to bring Chevron into this?
I'm happy to address it. So the reason we have the five-part DEA standard on currently accepted medical use is because that standard DEA articulated it at the very high watermark of Chevron deference. Since then, the Supreme Court has cut back on that deference steadily until Loper Bright, where they overruled Chevron and they said, we read the statute, not the agency. If they had applied that standard back in the early 90s when the five-part test was made, we wouldn't have a five-part test, I can assure you. But that is where we are now. And so courts, I think, are going to understand that when they look at the history of the five-part test and when they're looking at the HHS two-part standard. What we do know is that in this statute in particular, Congress said that DEA was bound by the scientific and medical determinations of HHS in this context. And if you look at a case called Gonzalez v. Oregon, it was written by Justice Kennedy back in the day. It talks about the CSA. That case had to do with assistance in dying and so forth, but they talked about how much deference, how much Congress intended HHS to have control over these aspects of the scheduling process. It's in the opinion. And so I feel pretty strongly that on those points, because of this statute in this context, we are in good shape, particularly with an OLC opinion. And last thing I'll say about it is courts realize it's unusual. The normal way that it works is you have a Democrat administration, they do a bunch of stuff. The Republican administration comes in, undoes everything, and everything switches around. And courts are used to getting that switcheroo happening. And they realize that that's political. And that's okay sometimes, but sometimes courts are skeptical of it. Here, we're in the unique situation where if we got rescheduling, you would have two administrations that don't usually get along from two different parties in a divided country, both agreeing about this particular issue. And I am 100%, I can assure you that unique situation will not be lost on a federal court looking at this. They will see that, they will understand that. And so those are reasons that I feel good as the lawyer here about where we would be if we got a final rule that put us in Schedule 3. That's what's making me feel comfortable. But as a lawyer, of course, I'm never, it's my job to be aware of the risks and the potential problems. And so that's where I tend to focus my attention rather than announcing victory before we have it.
Right. Look, I mean, two more questions. Someone is asking about the various cases related to cannabis that are on the docket, potentially going to a Supreme Court, right? Especially those cases around guns. So one person is saying the DOJ Solicitor General is urging SCOTUS to hear one of five relevant cases to resolve conflicting lower court decisions on gun rights for cannabis consumers. Any comments on that?
I mean, I think, look, I'm from Texas. I'm here with my family in Texas. My wife is from Texas. I grew up in Texas, and hey, I was talking to one of my brother-in-law about this these cases in 922G3, the provision that basically says that if somebody has a medical marijuana card from their state, that from their physician, their state licensed physician, that they somehow forfeit their Second Amendment rights. And I just think that somebody should, I don't know what this case says, the one that they're urging to be taken up, but I mean, I just imagine a case where you had, a combat veteran or the spouse of a combat veteran that died, who their doctor has said for the depression or PTSD that you're dealing with, you ought to have marijuana to help you with that. And the federal government telling the spouse of that combat veteran that, sorry about your warrior partner who died and isn't there to protect your family anymore, but you can't have the medicine that your doctor says. So, and if you do get the medicine, then you can't defend your family in your home with your Second Amendment rights. I find that outrageous. And I struggle to understand how that won't get corrected either by the courts or by the legislature at some point, because it's astonishing and embarrassing.
Right. Thank you. Look, Shane, you've been very generous with your time here, and I'm sure the audience appreciates all your insights. Closing remarks, I guess my last question would be, and I know we've touched on it many times in this conversation, but maybe just summarize your best prediction in terms of how things play out and just remind us about the timeline. And I know it's none of this is black and white, but yeah.
Sure. So, I mean, my hope and where I have allowed myself to be cautiously optimistic that we're heading is that the president is looking at this, that, Pam Bondi will end the pending hearing process that no longer has an adjudicator, that we will get a final rule that addresses the comments and gives a reasoned explanation for why cannabis ought to be in Schedule 3. I anticipate that at that point there will be litigation, and that litigation I don't anticipate, giving rise to a stay, and so we will have, 280E relief 30 days after the final rule is published in the Federal Register, and I feel good about our chances in that litigation. In part because I think I'll probably be a part of that litigation, and I always like to have the ball in my hands in these situations. I'm sure Dwayne, who's apparently listening, feels the same way, as he should. So I feel good about it. As far as timelines, it's just so hard to predict. But with the president telling the attorney general publicly that they, are going to have a decision in 2 weeks, I imagine that they will. And if they have that decision in 2 weeks, it shouldn't take an inordinate amount of time to get that final rule out. They will have to write it if they haven't started already, and it will have to be vetted through the, bureaucratic process. So lots of people will have to look at it. But, I would say that shouldn't take more than a month, 2 months max, for that to happen if they haven't started it already. And so I think we should finally see the end of this tunnel shortly, and that's what I think is going to happen.
Right.
Um,
Look, I don't want to get ahead of myself here, but and just to follow up there, I know we're with closing remarks, but given the president is so public about all these topics and has been so public about it, the way I see it, he's going to come out and say, look, we've decided we're going to reschedule, and I told Pam to write the final rule, and she's going to get on it. Does that seem to me like the most plausible scenario? And then she can take a month or two to write it, but at least we know the news. Or no, you think there'll be a bit more hush hush about it?
I really don't
Yeah,
know.
I know, but
I really don't know. I mean, I hope that we know what's going on. I think that would be ideal. And I don't know what the politics of saying, yes, we're going to have that or not. Looks like my kids are back from the beach.
it's fine.
Hey,
Yeah.
baby, I'm on a podcast. I love you, baby. I'm doing something right now.
She can stay there. I mean, we won't mention what we're talking
So,
about, I guess, but
so I think that we'll get it done. And I think that if it were me, I would announce it because it's politically a very popular thing.
right.
So
That's my
that's what
point.
I would do, but I don't
Well,
know what they're going to do.
and then Pam can take as long as she wants, but at least the news is out.
Yes. Yes. I mean, again, I don't think it should take all that long once they've made the decision.
Right.
These things can drag on, and I hope that that doesn't happen here. And the president look, the fact that the president of the United States is saying this is going to get done, the fact that Cole in his, comments said that it would be a top priority,
Yeah.
it seems like
Overseeing.
all of the signs point to that they understand this needs to get wrapped up. I expect it will. I
Right.
just don't know. I don't
So, I
know
mean, Cole didn't put
better
it on
than
his
that.
priority list, right? When he went to, he didn't put it on his priority list of priorities recently, right? When he was doing that.
That didn't really bother me because,
Yeah.
he was talking about enforcement priorities, first of all. And second of all, the priorities that he did say very much seem to include this in it. Like, if you want to end the cartels, and you want to end cartel control over things, it seems to me cannabis rescheduling would be one of the first moves you should make, because the cartels don't want steeper competition from a regulated market. That's one of the great selling points of Schedule 3, in my opinion. So I think people freaking out about that maybe aren't. Um, I mean, that's not how I saw that news. And
Mm.
look, I know this is how people have to be with stocks, and they're trying to read the tea leaves. But I'm telling you, as somebody who has been doing this a long time and knows about as much as anybody about this type of process, I've said forever, and you can go check my receipts on this. I'm public on this, that I said it takes a long time. Everybody needs to wait. This is the first time that we have the president saying, I have a date certain for a decision. We have gone all the way through the process. And by the way, there's one other thing that I do want to say about this. We took a lot of heat for bringing that interlocutory appeal back in the day. I just
Mm.
want everybody to know part of that strategy was to give the Trump administration time to get set up and able to make this decision. And here we are. And if the Trump administration didn't want to do it, we were pretty much screwed. And so I knew it made sense to give them the opportunity to do it and do it right. That's what we were, that this was, we've been playing this chess game for a long time and we're winning. Okay. So I know it's taking longer than people would like, but if you look historically, we're actually moving pretty quickly and we have such a great record. We've built such an extraordinary record here and we're very close.
Right.
And so I think we just need to wait for the process to play out. I know people have been waiting a long time, me too. But I think we're very close to the end here, and that's all very positive.
Just very hard for me to see them making a U-turn, right? After coming all the way here. And then he's talking, we'll have a decision in a couple of weeks. And Kamara say, you know what? I decide I'm not going to reschedule. Man.
Look, if they if cannabis stays in Schedule 1 after this, I, as a person who makes his living in the administrative processes and in the federal courts, it would be hard to convince me that this would ever get done administratively after this if it doesn't happen now, right?
Mm.
And at that point, you would need legislation, I think, because we have fought it and won at every single turn up to now. HHS, OLC, DEA colluding with Kevin Sabet, an ALJ hearing that was a total, clown car situation, and we just kept pegging them down over and over, and we've won at every stage. If it doesn't happen now, then I don't know what to tell people. It's been done right, and we're right there at the finish line. We just need that last push.
Yeah, I'm going to add one more here, and I'm sorry here. So it's like, it's really Pam Bondi, the one writing or and her team writing the final rule. DEA, and they have the authority based on the OLC opinion. So the DEA is not going to be so involved, right? The fact that Terry Cole is deputizing as a police force chief now in DC and those type of things are not factors really, or do they get in the way?
They shouldn't, because DOJ said DOJ would issue the final rule.
Right,
As
right.
I've said before during our conversation, that is something that changed, right? Normally it's DEA. It changed in this case. It could theoretically change back.
Right.
But unless it changes for some reason, which I can't imagine why, but unless it changes for some reason, they should do what they said. DOJ should issue the final rule. So I would expect, based on the evidence I have, that DOJ would issue the final rule. Look, it would be great in another sense. Like, I'm fine if DEA wants to write the Schedule 3 final rule. It'd be great for DEA to finally,
Yeah. Sure.
you know,
Mm.
finally turn a page. It would be great for the agency. I would, I don't know what interest they have in continuing to dig themselves deeper on this,
Mm.
but I would anticipate it being DOJ.
Excellent. Thank you very much, Shane. Great insights. I'm sure the audience appreciated all the conversation here. So, Shane Pennington, partner at Blank Rome. By the way, I'm not gonna. Blank Rome hosts a very interesting event. I think on October 27th in Boston.
Yep.
If anybody wants to sign up for that, it's on their website. But
And I'll
Shane,
be there.
again, thank you very much.
Thanks so much for having me. Thanks everybody for tuning in.
Have a good day, everyone. Thank you.
Thank you.